Hello? No. Yes. Okay. It's a very great pleasure to me to introduce you Jo Shaw from Edinburgh. She's the head of the Institute for Advanced Studies at the Humanities in Edinburgh. She is one of the key experts when it comes to citizenship and the European Union. She has done work at the different levels of the European Union and how, for example, the local levels, how citizenship affects the local levels or the transnational level at the European Union. She was also interested in looking at the transition in Yugoslavia and the role citizenship played at the time in the 90s. So she's also interested in where citizenship could resolve conflictive situations, maybe. And now she will talk to us to the, I would say, the most contemporary question, which is creating turbulences maybe from tomorrow on leaving or remaining. What is the role of the migration mobility regimes and the interconnection with the Brexit cause in these days. So you have the floor, Jo, and thank you for being here.
Thank you. Thank you very much. Can everybody hear me okay? It's a pleasure to be here. I don't think you switched it off. So I'm going to use a presentation style, a presentation package called Prezi. So if you're particularly prone to seasickness, you might want to close your eyes during the slide transition. Yeah, it's a pleasure to be here. It's certainly a pleasure to be outside the UK today. Don't worry, I've voted. I voted twice, actually, because I also had a proxy postal vote for my son, who's now in Singapore. And I entertained myself by sending him a picture with my finger hanging over one of the boxes, and he texted me back immediately saying, "You know what to do." So that will emerge. So the choice here that is facing the now 46 million electors in the UK, it's gone up 2 million since the last count in December, which would have been what was counted for the May local elections and Scottish Parliament and so on elections. 46 million electors are being faced with the question whether to remain within the European Union or to leave. And as Jenny said, I'm going to talk a little bit about how some of the questions of migration, mobility and citizenship play out in the UK's referendum on membership of the European Union on 2 dates. I'm talking on the 23rd, it's on the 23rd, or potentially scenes from a referendum could be another subtitle to this presentation. And I'm going to interpolate some of these scenes in and amongst my slides. Please don't take, as it were, this paper too seriously. It's based here and there on proper analytical research, which I've written about in various papers that have been published or are going to be published, but the actual sort of compilation, if you will, particularly given what I'm doing today, which is completely contemporaneous and also some of it quite emotional, as you'll see, is probably more descriptive and less analytical. So please don't ask me questions at the end about my analytical frame for this paper. So like I said, scenes from a referendum. So these are the questions I'm going to briefly elucidate. How has immigration come to play a major role in the debate? Are we referring here to discourses of migration or mobility? Secondly, what are the possible ramifications for immigration and for free movement of the variants of vote to remain and vote to leave? My argument here, and again, I'm developing this separately in a more analytical way, is that Remain and Brexit are mutually constitutive outcomes, regardless of what happens today. And then thirdly, what are the democratic implications of the vote? Mainly in the narrow sense of who can participate in the referendum, but right at the end I'm going to speculate on what are the consequences of some of the different scenarios. The other thing is I've absolutely no idea how long this is going to take. It might only take about 20 minutes, half an hour, so I hope you won't feel shortchanged if it does only take that long, because I'm sure there'll be lots of questions and we can elaborate on other issues if it doesn't take that too long. The background, if you will, is the background of this project, and I'm indebted to the colleagues here who've been developing their analytical take on the relationships of mobility and migration. And as I say, I don't really have a great deal to add to that. What I can simply do is sketch out the UK's relationship with free movement. I can say a little bit about the UK and EU immigration policies since JHA through to Freedom, Security and Justice and Lisbon stroke the TFEU. And then I can say a little bit about immigration policy in the UK since 2004. And in that period of time, I would argue, and I think in a way this is the most important point, I would argue that on a continuum of migration governance, the distinctions between immigration policy based on the exercise of national sovereignty versus free movement, if you will, based on a relinquishing of national sovereignty to create a compact amongst member states that in turn gives rights to individuals in relation to free movement, which clearly do not exist in relation to classic sovereignty-based immigration. It's that elision between the two that really is the interesting background to what's happening in the UK with this. Now, in relation to the UK and free movement, I would just say by way of background that although I'm going to say since 2004 we've seen this movement, nonetheless, that you could always, if you will, see a sort of a potential bifurcation going on in the legal construction of free movement in the UK right back to 1973. There was a series of cases in the 1980s which arose because the UK started in a gentle way to, well, relatively gentle, I say gentle compared to what it's doing now, started to assert its welfare sovereignty by identifying individuals that it didn't think were any longer qualifying community nationals, which is the language of entitlement free movement, which is deployed in the UK implementing legislation, and started sending people letters saying, basically, we're minded to think you're not qualifying, you should basically bugger off, but we're not going to do anything about it, but we will make sure you don't get any benefits. So it's a sort of starve them out type approach, was already taking root at that time, and it can be seen in a number of cases, and in those cases there's a very interesting case called Romelian and Volker. Interesting not for its facts, which are quite banal, but because it's one of the few instances where judges articulated a sense of what is distinctive about border governance in the UK. So being an island nation, having the right, having the actual presence in the UK being subject to something called leave, permission. So it's a permissions-based process, and it's very, very distinct from any, I think, other constructions of immigration policy or immigration law, which are based, yes, on a very strong distinction between alien and national, but nonetheless, aliens in certain stages can accede to various rights. So it's not through the weakening of the development of permissions. So if you will, if you applied a sort of Hofeldian analysis of rights and duties and obligations and permissions and so on, you would find that there is a distinctive approach in UK immigration law. Now, that was one of the reasons why the UK didn't participate very fully in much EU immigration policy since the development of those measures from the 1990s onwards, with the exception of measures that related to irregular or so-called illegal migration, where the UK was more enthusiastic, and of course in relation to measures relating to asylum. And that's got more and more complicated as the sets of opt-outs and opt-back-ins have got more complex through the treaties as they've developed, JHA through Maastricht, through Amsterdam, through to the Lisbon Treaty, which has reconstructed the treaty framework. And the UK is very much opted out of most of EU immigration law as it applies to most of the member states, and partially opted back into a small number of measures. And where it can, it continues to resist the development of more common measures. So what can we say then about immigration policy in the UK since 2004, and why have I picked that date? Well, I think many of you will be familiar with the fact that the UK in 2004 was one of a small number of member states that chose to allow EU citizens from the new member states that acceded in 2004 to exercise their labour market freedoms from the moment of accession onwards. And that had what for most people seemed to have been unanticipated consequences. And it would appear that this was not done out of some sort of liberal impulse, but simply because due diligence on the numbers, likely numbers, was not effectively done. And so consequently, what was expected to be relatively small movements, of course, turned out to be much larger movements. And since then, we've seen a complete explosion of the construction of the relation, of the, if you will, the blurring between immigration from third countries and immigration from EU citizens, from EU member states. Complicated in the context of the UK by reference, of course, to the Commonwealth. The Commonwealth itself then splits into the white Commonwealth and the not-so-white Commonwealth, and that then represents a sort of, if you will, a sharp post-colonial division for the UK in relation to the countries that experienced their relationship with the UK very strongly as a colonial one, and those that didn't experience it so much as a colonial one and rather quickly developed into autonomous entities, or of course in the case of one famous country very famously overthrew that at a very early stage and went its own path with very distinctive outcomes as well, in the case of the United States, which is another separate set of questions in relation to immigration into the UK. The reason why the Commonwealth, non-Commonwealth, the Commonwealth EU split is interesting in the UK, one reason for that is that the UK has a lot of former Commonwealth citizens, and many of them are still, some of them are still Commonwealth citizens, but they actually have the right to vote, and of course their descendants have the right to vote. And in the context of those ethnic minorities, the admission of non-skilled workers from the EU member states when in relation to the Commonwealth countries or other third countries, either very high skill levels, high income levels, or it has to be family migration or some other form of refugee or asylum or temporary protection or some other form of special case. There is a certain degree of resentment and friction between these different types of immigrant communities in the UK, and of course some of them have the right to vote in the referendum, and some of those communities are more substantially naturalised British, or their descendants have always been or have become British and have now grown up, because the Commonwealth communities are rather more long-standing than the bulk of the Polish community, although there is a long-standing Polish minority as well in the UK, particularly after the Second World War. Now, I think that a useful sort of analytical tool to examine then how member states have oriented themselves to the demands of free movement since 2004, 2004 being not just the enlargement, but also the date of the adoption of the Citizens' Rights Directive, which substantially codified EU free movement law and adopted one or two important novelties, such as the right of permanent residence for EU citizens who've been resident for 5 years or longer, and more substantial protections, in particular in relation to deportation in the event of public policy, public security issues for those who commit crimes, particular protections for those who've been there for 10 years or longer. A useful analytical tool is to understand what's going on in the UK or in other member states as a continuum of migration governance. It's all about the policy mix around issues of immigrant selection, immigrant integration, and also a sort of rights, duties matrix, rights, duties, permissions matrix when you come to assess the legal dynamics of it. And in that context, what I've argued in one of the papers I've written in this area is that what member states are doing, and you can see it particularly clearly with the UK, is that they exploit any wiggle room they have in relation to EU free movement law in order to restrict its effects. They try to read across into EU free movement law from the area of immigration law in order to make EU free movement more like immigration, because that's largely what public opinion does. It aligns the two together. And politicians, to a certain extent, are trying, I think. I can't prove this because I don't have the data, so this is anecdotal or inferential merely. My inference is that politicians are trying to bring what's happening into line with what public expectations are. And then they've been, of course, seeking to change the resource base of free movement law. And that carries me then on neatly to free movement in the UK renegotiation. And what you see there, that rather lengthy and somewhat dull quote, is a statement about the free movement of workers from the Council draft decision, which will become an actual decision, European Council actual decision, in the event that on the 24th, after the referendum, the UK government, presumably in the person of its Prime Minister, makes the statement that the UK intends to remain in the European Union, at least for the foreseeable future. And that will become an actual statement. Now, what I'm interested about this is that it demonstrates, although it's in that renegotiation, that document is, of course, negotiated and agreed amongst 28 member states with substantial input from the European Commission and from the Council Secretariat, and in particular the office of Donald Tusk, who, the President of the European Council, undertook an awful lot of the Sherpa work in relation to, and he and his staff did, in relation to getting this agreed amongst the 28 member states. And what's interesting here is that this statement is very much about the conditions and restrictions on free movement, not about its liberatory qualities. Now, there are other things that are stated about its liberatory qualities, if you will, elsewhere in the document, but it's all about the limitations. And one of the interesting statements that's in there, that in my view, and of course I may know nothing, and I've spent the last 6 months being told, as someone who supposedly knows about EU law, I'm merely an expert and therefore superfluous to requirements. The statement, in addition, if overriding reasons of public interest make it necessary, free movement of workers may be restricted by measures proportionate to the legitimate aim pursued. I'm struggling to find the bit that the treaty says that, but anyway. Encouraging recruitment, reducing unemployment, protecting vulnerable workers, and averting the risk of seriously undermining the sustainability of social security systems are reasons of public interest recognised in the jurisprudence of the Court of Justice of the European Union for this purpose, based on a case-by-case analysis. Yes, but only in respect of indirect discrimination, that is, say, measures which prioritise residents, long-term residents over non-residents, and so on, but not measures which actually distinguish by means of nationality between different groups, which traditionally can only be justified on the basis of public policy, public security, and public health. Okay? So what I'm trying to argue here is you see that slippage of this language into the documentation of the Council of Ministers, into the documentation of the European Council. It's clearly not just the UK that is developing this discourse of slippage between migration and free movement, immigration and free movement. It's something that the member states are quite happy to think about changing the resource base. But they want to try and think about changing the resource base without actually changing the treaties, because they know that changing the treaties would be a nightmare scenario for them. Now, the specific reference points that have been developed have been ideas for to restrict so-called in-work benefits. These are the measures that are taken in the UK to deal with the fact that many of our employers pay poverty wages, which make it impossible to bring children up, even on a full-time wage. And those so-called in-work benefits are payable to anyone who's in work without any restrictions. And the UK wants to be able to pull an emergency brake in order to stop that by means of a transitional period and on a tapering basis and so on and so forth. And we can argue about both whether it's legal but also whether it would have any effect, and therefore whether or not there is actually a relationship between the problem that's been identified, and not everybody would agree with the problem, because actually unemployment in the UK is pretty low, very low, but employment rates are higher than they have ever been in the UK. So it's very, very, very hard to argue that immigration is having a negative economic effect in the UK. It might have small effects on a sort of localized basis on pressures on public services, but those are the sorts of problems that you can alleviate through territorial politics, not by smashing up the European Union. So anyway, so there's maybe a problematic relationship between means and ends, and in any event, the amount that this would address in relation to the public purse is so small as to be barely visible to the naked eye. It's a tiny, tiny, tiny amount of money, and doesn't address what the real pressures on the British public purse are. And the real pressures on the British public purse come from two things: pensions and the NHS. And those are the two things that cost them, in particular pensions and the untouchability of pensions. And that's fine. I may be drawing mine at some point. But it's the trade-off between the two results in certain types of things being taken out of public discourse and other things being brought into public discourse. The other issues that are in there are issues relating to the payment of child benefit, where the child is not resident in the host state, the possibility of indexation. Quite a few member states are interested in that. There are what I call attacks upon the Metot judgment, the Metot judgment being a judgment where the Court of Justice interpreted the Citizens' Rights Directive to say that a member state couldn't make it conditional on giving the right of residence to a third country national spouse, that the EU citizen and the third country national spouse had prior lawful residence in another member state before moving to that host state. And so there are various attacks upon that judgment. And then related to that, the continuing ramping up of exceptions to free movement towards a migration regime, and a much more disciplinary approach, for example, to issues around migrants who find themselves, if you will, at the edges of permissibility, those who commit crimes, even in some cases quite relatively minor crimes that you would expect they ought to be rehabilitated from, and also those who find themselves homeless or destitute in various different ways. And I don't want to go into all of the details, but you can easily find, with a modicum of searching, some quite distressing stuff relating to the treatment of these groups in the UK. Not just in the UK, but this is my particular concern. So I guess, as I say, coming back to the key point, are these merely clarifications of EU free movement law as it exists, or are they new restrictions? And that will be a very important question that we'll need to answer in the event of a vote to remain, because those measures will come to be implemented. And here I just take the case of the emergency brake very, very briefly, just run you through some of the key stages that might occur in relation to that. There'll need to be implementing legislation giving effect to the statement that's contained in the documentation about the circumstances in which an emergency brake can be pulled, which is like pressure on the welfare state. All of the things that economists, the overwhelming majority of economists say those aren't the pressures. There are austerity pressures in the UK, but they don't stem from immigration. They stem from other factors. So to starters, defining the circumstances in which the emergency brake can be pulled will be interesting. Question of the role of the European Parliament, I wondered if they might be difficult about it, but I spoke to one of the Scottish MEPs recently, and he said no, for sure. All of the mainstream parties will vote in favour of this implementing legislation. The question is whether or not the legislation itself will be challengeable and who might have standing to challenge it. That's an interesting question. And then once the test is set and a member state seeks to pull the brake, again, how will that proceed? What will be the role of the Commission? How strong will be the role of the European Council, the Council of Ministers? What might be the role of the European Parliament? Again, I didn't put that in. We were running out of space. And then again, will the measures be challengeable on grounds of discrimination, on grounds of nationality? And there's a couple of my EU law colleagues in Britain have got a lot of public salience for the work that they've done. I'll come on to one of them in a moment. But the other one that I would refer you to is Steve Pearce, who's done a tremendous amount of basic, quick and dirty, but accurate and communicative analysis of what all of this means on his EU law analysis blog, and it's certainly accessible to those who aren't lawyers but are, intelligent and engaged observers. And he argued that certainly the measures relating to the emergency brake are the most challengeable of the ones that are contemplated, and I would tend to agree with him. Of course, we aren't just talking about legal challenge, we should also talk about what the social effects of these might be. And some people have also pointed out that many of these measures will have a disproportionate impact upon women, particularly women with children. So there may be grounds for challenging them under the EU principle of sex discrimination on the grounds that they have a disproportionate impact on one sex over the other. Now, in the event of vote leave, we'll have, we assume, although no one knows, because many different prospectuses have been set out, but the usual, well, it's not usual because it's never happened. Normal science would suggest, and indeed the Council, I think it's in the Council, European Council papers, that there will be an orderly negotiation of the UK departure under Article 50. There might be the question of who is left as the UK government and whether we might end up with a general election, probably in December, in the event of that, and all sorts of other things. I'll come on to that in a moment. But you would normally expect in those sorts of cases the substitution of national immigration law for EU free movement law. And that's unlikely to be orderly, and it's unlikely to be easy, and it's likely to result in an enormous amount of individual suffering, if you don't mind me saying so. Because we're talking about millions of people being subject to administrative adjustment of their rights. Now, if you draw what might be an unfair analogy between this and what happened to various citizens of Yugoslavia who ended up in the wrong state or in the wrong republic on the collapse of Yugoslavia, in several cases, most famously Slovenia, but not only Slovenia, they found themselves being erased when really they should have been moved onto the register of resident aliens. And I'm not suggesting for one moment the UK would do this, but when you're talking about millions and millions of people whose situation needs to be regularised, and you have a very small and frankly incompetent bureaucracy that makes a huge number of mistakes at the moment, and I can give you all the data relating to that if you want, the idea is horrifying that this would have to happen, and what its impact on people's lives would be, and consequently what the likely impact would be, knock-on impact would also be on the British economy as well when people start leaving in droves because they don't particularly want to be subject to this type of process. Okay, now some people have argued that acquired rights under international law would protect. I think that's a misconstruction of the Vienna Convention on the Law of Treaties, but it had its moment in the sun for about a week during the referendum campaign. Some people have tried to argue there might be some sort of hangover from EU citizenship, perhaps an EEA type agreement or Swiss type arrangements. And of course there's individual action in this context, acquisition of another citizenship by long-term residents or those with jus sanguinis external options. And I can speak to this issue with personal experience. My partner is currently going through the very interesting process of trying to prove that he is Irish by descent, because he's descended from a grandfather who was born in in the 6 counties in Northern Ireland in the very early years of the last century. But his life is complicated, substantially complicated by the fact he then married a woman in Australia, albeit of Irish descent, but that doesn't matter. And then my partner's mother was also born in Australia. So he not only has to get the birth certificate for his grandfather, he also has to get the Australian birth certificate for his mother and the Australian marriage certificate, and that then becomes extremely complicated. But anyway, people will take your sanguinis options. The Irish have anecdotally noted that they've had to take on an extra 200 people to deal with requests. It's estimated that up to 7 million people in the UK could acquire Irish citizenship by descent from their parents. And I might even think about marrying my partner if I could get it then by marriage, if it got that. But otherwise, I'm a marriage resistor and I don't really do marriage. But I would do it for immigration reasons. So remain or leave. So onwards and upwards, or downwards. Well, actually upwards. So this bit is the bit where I might get a bit more emotional about it. This is my pal Michael Dugan, who I saw just about 10 days ago in Liverpool, because I was doing some work for them there relating to their research and stuff. And he was talking about the work that he was doing, very thorough, good work that he was doing, talking to various things. And then Liverpool then released this video, which must have been done around about the same time. And this video has gone viral. Just on YouTube, 293,000 views. I took this off earlier on this morning, but it's on various other platforms, and you can view it just through Facebook, which probably doesn't increase the counter on YouTube. It's literally being viewed 1 million times. But the really interesting question about this, and this is all anecdotal, it's all a bit of fun, is this? It's not more than that. It's been viewed probably millions of times, and it's been tweeted about. And it's been tweeted about by Gary Lineker, said, I changed my mind because of this video. Watch this video because it will make you change your mind. And in fact, I put this to the test last night because most of my Facebook pals are inevitably, because we live in semi sort of closed off communities, don't we? So most of my Facebook pals are Remainers, and we're all talking to each other about how desperately important it is that we remain, which is fairly futile. But then some parents of a friend of my the parents of a friend of my son's, who are a couple of people. They live in South Yorkshire, West Yorkshire, but sort of between Leeds and Sheffield. They live there, always have lived there, and I'm friends with them on Facebook. And one of them said, the mother said last night on Facebook, Harold and I are voting leave. And I thought, oh no. So I thought, well, individual action, this is what we have to do. So I messaged her with the thing, and I said, well, obviously it's for you to decide what you're going to do. But please promise me you'll watch this video first. And then about an hour later, she messaged me back to say, Harold's wavering, and I'm 50-50. And there were some good arguments. And I thought, good on Michael. And these are the these have been the sorts of things that have happened to us. It's not really been present, and I know Michael was really, really angry, and he expresses that to a certain extent in this lecture. This was 25 minutes talk on the referendum. As he says, there have been lies on an industrial scale by the Leave campaign, and then it's very hard to know where to even start in reconstructing that. And I've experienced that in the relatively small number of public activities that I've done in relation to the referendum. Anyway, so that's Michael Dugan. So that's scenes from the referendum. But back to the serious stuff, or more or less. And this is the bit that Jean Thomas was presaging when I rudely interrupted him and said it was too hot in the room, we've got to get out. And that's the relationship between the franchise and democracy. And we've got quite a lot of experience on dealing with the franchise and constitutional referendums in the UK. And I talked about this issue a week or so ago it was exactly a week ago, at an event that I did, and somebody tweeted, "Oh, Joe Shaw explained the relationship, the franchise issue in 8 minutes, and it was brilliant." And I thought, oh yeah, well that's cool. I like that. But I don't think I've even got 8 minutes to explain it here because we're doing quite a lot of other things here and starting to run out of time. But basically the franchise definition, and you see it when you think about the relationship between the EU referendum and the Scottish referendum, is really about how do you create a defensible demos for a particular franchise. With increasing mobility, what constitutes the people who have a legitimate say? Do you apply an all-affected interest principle? Do you apply some sort of stakeholder principle? Or do you simply largely take the franchise that's used in the general election or the national election or the regional election and use that as the basis for your referendum franchise? And that's essentially what's been done in the UK with these two referendums. In the Scottish referendum, that meant, because that's who vote in the Scottish Parliament elections, EU citizens and 16, 17-year-olds. Well, actually, it was an innovation with the 16, 17-year-olds. That was the first time that they voted, but they have voted in subsequent Scottish Parliament election that was held this year. It's a new norm of voting for Scottish Parliament elections is to lower the franchise age to 16. And no non-residents at all can vote. And that means not even Scots who moved to the rest of the UK or Scots who've moved to outside the UK. Absolutely no residents. It's a residence-based, no non-residents. It's a residence-based franchise. Now, consequently, in the EU referendum, you have which was the franchise was set in the EU Referendum Act, and it's been challenged. You have no external. You don't have no external voters. You have the same group of external voters who vote in the national elections. That means external voters can vote for up to 15 years. The slight sort of question that's raised about this is that the Conservatives, along with a manifesto pledge to hold a referendum, included a manifesto pledge to extend votes for life to external voters, but they haven't got round to implementing that one. But sadly, they did get round to implementing the pledge to hold a referendum. Don't we know it? We've been enjoying it. Now, two people challenged this. Harry Schindler, who's previously taken an external votes claim before the European Court of Human Rights, and Jacqueline McLennan, who's a solicitor in Brussels, Scottish solicitor in Brussels, and they've both been outside the UK for way over 15 years. And they challenged it and said that we have a particular interest in this referendum, and we should have a right to vote. Arguments in the courts, it went quickly to divisional court and then to the Court of Appeal, and then they heard some oral arguments in the Supreme Court about whether they would do a full hearing, but then they said they wouldn't do a full hearing. So the last substantial judgment is that of the Court of Appeal. And the Court of Appeal said that the whole issue of Britain's referendum franchise is outside the scope of EU law. Article 50 refers to national constitutional processes for ratifying any agreement. So consequently, that's surely that would be the only basis that it can't be interfered with by EU law. The Court of Appeal basically said, you know, it's a matter of national sovereignty and it's walled off from EU law. And in order to make that argument, it drew its inspiration from what the only court that I know of that's interpreted Article 50, which is the German Federal Constitutional Court, mentioned Article 50 in its Lisbon Treaty, but then it mentioned almost everything in about the 350 paragraphs of that judgment. But it did mention Article 50 and said that this would be a matter for national law to determine the applicability, if you will, of the criteria in Article 50. The notable thing in the UK is that essentially there isn't really a constitutional right to vote, or at least not one that is usable for arguments around where you're imposing bright line rules, such as cutting off strictly at 15 years when there's no particular reason why 15 years is better than 14 or 16 or nothing, or any other criterion. Other member states would have a constitutional right to vote that would be susceptible to that. So we've seen, for example, challenges in Germany to the imposition of a threshold in European Parliament elections, which the Federal Constitutional Court said was contrary to the constitutional right to vote and equality of citizens in a democratic context. In all of this, what's been largely lost has been the non-inclusion of resident EU citizens, affected, as I pointed out in the previous section of this lecture, in rather specific and problematic ways. So there's Harry Schindler and Jacqueline McLennan. Believe in Britain. So just a little bit more then on the sort of what's going on and the public discourse and so on and so forth, just as I wrap up. There's a sort of compilation of newspaper responses with the Sun right at the front. Funnily enough, that wasn't the front page on the Sun when it was sold in Scotland. It was different. I wonder why that might be on that day. But nonetheless, they took a strict line, and quite a few other newspapers have done. And what we can see, I think my slides have got out of order. No. It's right. What we can see in the UK is a very, very distinctive territorial pattern. And that's the latest data that was released by YouGov based on its regional polling. It excludes Northern Ireland. Those of you who are sharp observers might have noticed that. But it does include, no, it doesn't include Gibraltar either, which is also enthusiastically in favour of remaining. And I've just questioned here about what the different scenarios might be. You know, we might get all of the UK votes to leave or all of the UK votes to remain. I think that's very unlikely. We are likely to get, much more likely to get some sort of split. So the most likely scenario is this one, which is that England minus London votes to leave. Scotland, probably Wales, although look at Wales there, because the most populous parts of Wales are actually down in the south, and they're quite leavy. Yeah? The bits up here have just got sheep in them, and they can't vote yet. Sorry, remaining. Red is remain, isn't it? Yeah. No, sorry, there's some quite intense, you can't really see, but there are some bluey bits down here, and you can see it's all very blue there. And that's actually Wales, most of it, I think, and so on. And of course, you can see that the most intensively blue bit is the bit around Lincolnshire and stuff like that, where the rate of immigration is almost the lowest in the UK. But there we go, we live in irrational times. So the most likely scenario is that England minus London will vote leave overall. Will be more than 50% leave. Scotland, to a certain extent, Wales, Northern Ireland, London, intensively. You can see how red it is. Gibraltar, vote remain. Now, the question is, where does the balance then go? Is that tips the boat, because England is more populous than any other part of the UK, that tips the vote to leave, in which case, do we get then the breakup of the UK? Or, if England only narrowly votes leave, in which case the more overwhelmingly remain parts of the UK carry it in, what happens then? England declares independence? England expels Scotland? All sorts of interesting questions then arise, which are likely to provoke constitutional questions in the UK's multi-level governance system for quite some time to come. Who indeed will speak for England? Funnily enough, this headline in February was not carried in the Scottish Daily Mail. Indeed, the Scottish Daily Mail has its own distinctive voice on referendum. these are the two front pages on the same day. So very distinctive voices. So you can see there's a strong territorial variation that's going on in relation to the referendum, and it's accentuating those territorial variations. But let me just now return to the question of immigration. This is a compilation of Daily Express headlines that was put together by various people. I've used various of these types of compilations before, demonstrating the complete and utter obsession of the Daily Express, which is another of these tabloids that's Brexit focused, on migration and the illusion of migration, the EU, third countries, and so on and so forth. A complete illusion of these issues. But for these purposes, that point isn't really the one I want to make, not the conceptual question of how we deal with that. On the contrary, I want to make a more serious and consequently more emotional point that comes out of this. On the 16th of June, that's exactly a week ago, a man called Alex Massey, who's a Scot, who writes he pens his stuff in The Spectator, which is a more conservative or right-wing magazine, weekly magazine, but also carries a very widely read blog, political blog. And his point here is about a particular poster that was published by UKIP on the 16th, in the morning of the 16th. And Nigel Farage posed in front of it. And I don't know whether many of you saw it, and I didn't want to put it on here because I find it too upsetting to look at it. But it's a picture of a group of refugees coming in a row, in a sort of circle towards the Slovenian border, I think. And basically the message is, you know, if we don't leave the EU, these guys are going to swamp you. And it focused on the fact that they were predominantly male, they were therefore predators. There were quite a few children in there, as you can see. It was a very horrifying poster. And this is what Alex Massey very eloquently had to say about this. The mask, the porky gin o'clock, you know what I mean, mask. It didn't slip because there was no mask at all. Breaking point, that was what it said, breaking point. It screamed above a queue of dusky-hued refugees waiting to cross a border. The message was not very subtle. Vote leave Britain or be overrun by brown people. Take control, take back your country. You know what I mean, don't you? If you want a Turk or a Syrian for a neighbour, vote Remain. Simple, common sense, in it. But still, look, when you encourage rage, you cannot then feign surprise when people become enraged. You cannot turn around and say, mate, you weren't supposed to take it so seriously. It was just a game, just the ploy, a strategy for winning votes. When you shout breaking point over and over again, you don't get to be surprised when someone breaks. When you present politics as a matter of life and death, as a question of national survival, don't be surprised if someone takes you at your word. You didn't make them do it. No, you didn't do much to stop it either. This is a picture I took on Thursday at about 6:30. I think you all know what it's about. Thank you.
I think we open immediately the floor so that comments or questions can be asked. Who would like to start?
Not much to say. Really.
Nobody. But how realistic, you are from Scotland, how realistic will it be basically that after the first Scottish referendum, there would be a relaunch of independency in the northern part of the UK?
Oh, I think it's very realistic because I guess I'm not representative, but certainly a lot of the people I know who voted no in the Scottish referendum would regard leaving the EU as more significant than leaving the UK. So I think, particularly if the UK demonstrates its values in the aggregate on that basis. So I think it will give rise to a very big question, and I don't think there will be any hesitation to start to raise that question. What will come of it, I don't know, and to what extent it will simply just be I don't know, more of what we saw after the 1979 devolution referendum, where Scotland voted yes, but not by a high enough percentage. Excuse me. And then after that, when things started to go really wrong during the 1980s for Scotland, with the miners' strike, with the decimation of the mines and other heavy industry in Scotland, and the imposition of the poll tax, which was seen as using Scotland as a live laboratory. Basically, Scotland developed a lot of sort of shadow civic institutions to discuss the various implications of devolution and so on. And eventually those shadow institutions became the real institutions of devolution after 1997. Excuse me. And so we might get that type of scenario, but I think that we're not in stability anytime soon. You can see how split the UK is, and it doesn't currently have either the mechanisms or the public culture to deal with that diversity. You know, I might regard my position as perfectly natural, but you know, so do other people.
That was the remark Joan made about the expulsion of Scotland by England.
Yeah.
I guess that was...
It wasn't a strict legal statement.
No, but it was very interesting, because that would be a discussion which comes up if the Scots in far majority vote Remain, but that clear majority in England would be Leave, isn't it? And how likely is that then discussion comes up in England to have a referendum in England to leave the UK?
Well, Michael Keating, who supervises a number of people who sit in this room, has always said that the more likely scenario for the breakup of the UK is that England leaves, not Scotland. And he may prove to be right in the long term. I'm not such an acute political observer of these questions, so I'm largely assimilating, synergizing, and exposing, as it were, those points. What certainly will be the case is that, well, after the Scottish referendum, on the morning of the day after, which is the 19th of September, in a very ill-judged statement, David Cameron went on the steps of Downing Street and said, yep, okay, what about England? And a statement which is, having just voted to keep Scotland in the UK and regarding myself as, you know, I mean, I nearly kicked my television in because I was so angry that he should exploit it for that type of political advantage, essentially, because we're not. Yeah, okay. I mean, we're surrounded here by experts on nationalisms as imagined communities. We're not necessarily talking about people whose psychological reality is somehow completely different. What we're talking about is people whose patterns of political representation are different. And that's what's happened in Scotland, the pattern of political representation based on perceived value systems, which actually, when you come to survey them, are not that different to England's value systems, and in terms of attitudes to immigration or public services, a little bit different, but not massively different. But patterns of representation have come to be completely different. And in that context, we don't have the political institutions in the UK to deal with what comes out of that in terms of conflicts of territorial politics. We don't have functioning institutions that deal with that, either in the form of a proper federal system with everything that might follow from that, or something else, some more robust institutions that deal with the type of asymmetric federalism, informal federalism that we operate at the present time. And so that's why that Daily Mail headline, "Who will speak for England?" After Cameron did that, I think what then happened, either just before or probably just after the general election, they changed the majority in the House of Commons, but they didn't really need a sort of formal legislative process to do that. Changed the standing orders of the House of Commons effectively to create an English chamber of the Westminster Parliament, so that you have this scenario of English votes for English laws. And this is the so-called response to the West Lothian question, the notion that with Scottish representatives voting on issues that affect only England, you have an asymmetry of political representation, a point made by the former MP Tam Dayoe. As a colleague of mine in Edinburgh, James Mitchell, said, what you have potentially with England voting to leave, but Scotland and other parts of the UK tipping the balance in terms of Remain, what you have then is the West Lothian question writ large, you know, on steroids, basically. And it's going to be very, very, very politically unstable. There's a micro. Yeah.
Is something like that possible? And how
Yeah, I mean, I've seen various headlines relating to, you know, London basically saying, you know, we ought to be independent, but, yeah, I've not followed it up, and it's hard to see how it's, you know, London isn't just London. London is also its hinterlands, which become increasingly less like London, yeah? But nonetheless are influenced by London. Certainly the house prices are. So yeah, it's an interesting question.
The last question, Mario?
Yeah, I really like your combination of law and politics, and emotions, and I was wondering if you want to become a Swiss politician. How Switzerland joined the EU. See some similarities there. But more seriously, is the issue of good faith or the sort of changed circumstances, class level circumstances, can we really leave the EU? Is there a good faith argument there? And what would it mean if Britain really leaves the EU? Would it be a real break? Or would it be more of the same of this sort of special rules that pick and choose, these kind of arrangements? I'm asking this a little bit because Switzerland has some problems with the Croatia protocol, and a good faith is an issue there, or has,
Sure. I haven't looked into this in particular detail, but one of my friends, Kenneth Armstrong, has written an interesting short paper that's on Cambridge's website. He's in Faculty of Law in Cambridge. If you Google it, I'm sure you'll find it, about subjecting the vote leave statements about what might happen, because vote leave encounters a number of problems. One is that they don't have a parliamentary majority in favour of leave. There's an undoubted parliamentary majority in favour of Remain. So that raises the question of what measures might then be taken. And they've previously suggested a couple of times that we might not really trigger Article 50, we might just sit on our hands, or we might start passing some legislation that is contrary to the treaties, or we might repeal the European Communities Act, but we'll just sit on our hands for the time being and see what happens, and wait for them to make us a better offer. So those are some of the arguments, and of course, as you say, there, you have issues of compliance with EU law. You also have issues of good faith in the context of international agreements, which is a very important principle, I think, in international relations. And I don't think many people in the Vote Leave campaign have any understanding of how international relations actually operates. It's almost none of them have any experience of actually negotiating anything at all, and they don't have a civil service backing them up. They're just a bunch of, well, lunatics, sorry. Don't quote me on this and don't recall me on that. Yes, so there are manifest problems. An interesting argument has taken hold in a sort of wider populace, if you will, that was articulated to me by a taxi driver in Liverpool. Always listen to the taxi drivers. A couple of weeks ago, when I was in Liverpool a couple of weeks ago, he said, and Liverpool will almost certainly vote quite strongly to remain because it doesn't see itself as being an English city in that way for all sorts of reasons. It's looks outwards rather than inwards. It had its major falling out with the Sun newspaper over the Hillsborough tragedy, and it regards itself as a city of immigrants that is very independent-minded. And it knows that it has problems, but it doesn't blame the immigrants for the problems. And he said, well, whatever people vote, we're not going to leave anyway, are we? So it doesn't really matter type thing. And I didn't want to pursue it any further because I wasn't feeling up to it, whether that meant he was voting Remain or voting Leave or not voting at all. And obviously I would have preferred him just to vote generally to keep the turnout high, but obviously I would have strongly preferred him to vote Remain, as I suspect the majority of his Liverpudlians will do. But that argument has taken root to a certain extent in the populace, that basically we can have a sort of collective left behind, messed around by globalization scream, yeah, that and we can blame the EU, we can identify the EU or the migrants or both or a combination of all of those things. We can have a collective scream, but then everything will carry on afterwards and it won't really matter. But of course it will, because it's such a major moment that, well, the pound went up again massively this morning, and the stock markets are rising again. So if it is Leave, so in other words, the city strongly expects a Remain vote. If it is a Leave vote, the crash will be awful, and the crash alone, because of the impact of that aspect of the economy on the real economy, will be enough to drive the UK into recession just alone, quite apart from anything else, which is just crazy. That is an act of inordinate self-harm in a country that is so interconnected with global markets, global financial markets. So, that's where we are.
Thank you, Joe. Thank you, Joe, for this very committed positions, and I think that we have learned a lot of domestic UK policy, but maybe we have also to learn more on EU shortcomings with regard to how this could happen, that we come to such voting, basically, too. So it's time for lunch. Sorry, I'm losing my voice. It's time for lunch, 1 o'clock. We see each other again at 2 o'clock. Lunch is provided at the 3rd floor according to the manuscript here. Thank you very much, and see you again at 2 o'clock.